Morning. Are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle, and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance. Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again, for punishment purposes. That would make this a second degree felony offense if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file with the court, and so I asked that it be reset for him to make those arrangements. That's what he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so.
Yes, ma'am.
Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay?
Thank you.
All right. Yes, good morning. You're Norberto Armenta,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
So, he will, Your Honor.
Let me,
And Judge, if we may proceed on what I have numbered as 1, 2, and 3, my position on that is it's the first paragraph, the second paragraph, which is a jurisdictional paragraph to get us to the DWI third, and then a regular felony prior.
Okay,
I see.
so technically
Technically 2. I just
two counts with
didn't know
the
if-
second paragraph.
how it kind of looks like a paragraph on its own, but it's just jurisdiction.
Okay, and so in cause number 25, DCCR 0168, you're charged with the third-degree felony offense of driving while intoxicated, third or more. That's from April 25th of 2024. The indictment alleges you were previously convicted of driving while intoxicated February 5th of 1998 in Harris County, Texas, February 6th of 2008 in Harris County, Texas, and then again September 8th of 2023 in Harris County, Texas. And then the second count in this indictment alleges that you were previously convicted of possession of a controlled substance, second degree felony, June 24th of 2004. And how do you plead to that charge?
Guilty.
And are all those prior convictions that I read out for DWI as well as the possession of a controlled substance true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 12 years in prison. And I want to make sure you understand what that means is you're leaving your punishment up to me. And as long as I don't give you more than 12 years in prison, then you can't appeal. If I can give you 12, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that, and is that what you want to do?
Yes, ma'am.
It shows also as part of this agreement that the state will dismiss cause number 25, DCCR 0169, and it will run concurrently with any other felonies that you are currently serving time on. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Perfect.
It's admitted. Is there any?
Now, this bond hearing just took an unexpected turn. The defense argued that the defendant missed court because he was already incarcerated in another. State not, because he was trying to run. But the prosecution pointed to a history involving guns and drugs. And the judge isn't convinced that lowering the bond is the right move. This is exactly how bond hearings work. They're not about deciding guilt or innocence. They're about balancing public safety against the defendant's likelihood of returning to court. So what do you think? Should the bond stay at $100,000? Or does the defense have a strong argument for reducing it? Let us know in the comments.
Any evidence that Mr. Armenta is not competent?
No, I'm aware of that.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing. All right, you can go back with the bailiff.
Your Honor, just to be clear on the paperwork, it reflects we're not requesting probation, we're requesting a five years.
I saw that, yes, sir, thank you. All right, you can go back with the bailiff.
I'll be out to suit.
Good morning, are you Jarrett Matthews?
Yes, ma'am.
In